Madam Deputy Registrar, could you open these proceedings?
Thank you, Mr. Justice Witt. Caribbean Court of Justice, Appellate Jurisdiction, an appeal from the Court of Appeal of Guyana. Hearing of the appeal in GYCV number 8 of 2021 between Alexis Loncke, Lawrence Zaman, and Olga Boatemma Addo. The members of this morning's panel are Mr. Justice Witt, presiding judge.
Good morning, Counsel.
Mr. Justice Anderson.
Good morning, Counsel.
Madam Justice Rajnath Lee.
Good morning, everyone.
Mr. Justice Barrow.
Good morning.
And Mr. Justice Burgess.
Good morning, Counsel.
May we have the appearances, please? Thank you.
Your Honor, I am C.V. Satram, and I appear together with Mr. Rupnarayan Satram and Mr. Ron Motilal for the appellant.
Good morning, Your Honors. My name is Roysdale Ford, and I appear on behalf of the respondent.
Thank you. I think, Mr. Satram, it's your turn now. So you can start.
Yes, good morning, Your Honor.
Good morning.
Your Honor, the appellant Alexis Loncke and her predecessors have had a long connection with the disputed land. Mitchell Gibbons presented a petition for a declaration of title in 1970. And that petition is at page 244 of the record. At paragraph 4 of that petition, he claimed that he and his brother Joshua had been in possession of the land since 1928. That petition was opposed by the current paper title holder. The opposers relied on an order obtained from the High Court in Chambers in 1967. And that order is at page 239 of the record. It declared that the title of all persons to the land was barred. Title referred to in the order is an 1842 transport held by a Cornelius de Wint. Your Honors will see that at page 239. Alfred Charles, Your Honor, one of the title holders, deposed, he opposed on behalf of all the owners, and he swore that a deflourment, Henrietta deflourment, collected rent from Joshua Gibbons until her death in 1962, after which he, Alfred Charles, took control of the land. Your Honor will see that at paragraph 7 of page 253. That is the affidavit in support of opposition. Joshua Gibbons died in 1964, and Mitchell Gibbons continued in possession alone. Now, the petition, Your Honor, referred to a lot 3, but it seems that the plan was later amended to refer to lots 5 and 6. And at paragraph 5 of the affidavit in opposition, Your Honors will see that Alfred Charles accepted that the land claimed was in fact part of lots 5 and 6. The issues in that petition, Your Honor, were never determined because it was withdrawn in 1970. And in our submission, the withdrawal of that petition had no impact on the possession which Gibbons enjoyed at the time. It did not change the nature or quality of his possession. There was no assertion in the proceedings, in the petition, that in the affidavit of opposition, that Gibbons was not in possession. The allegation was that he was a tenant of up to 1962 of deflourment, who herself had no title to the land. So we say that possession was not in time, was not interrupted by the filing and withdrawal of that petition. We say also that the possession was not interrupted with the passing of title in 1970, with the transport that was passed to the Charles family in 1970. So at the very least, a right of action arose in Charles in 1970 when that transport was obtained. A right of action may have arisen as well in 1967 when Justice Mitchell made that order in their favor. But no action was brought against Gibbons or his successors until this case was filed in 1996. The adverse possession, which commenced before 1970, was not interrupted by any action and time was running on the evidence of Charles himself, at least since 1962, when Charles said he took charge of the land. In our submission, by 1975, the title had been extinguished. Now, the trial judge felt that there was no adverse possession between 1970 and 1975, because as she put it, Gibbons was in possession of the house and not the land. Now, the Court of Appeal corrected that error at page 33 of the record, and specifically at lines 12 to 14 of page 33, and also on page 34 of the record. The Court of Appeal felt that there was a period of adverse possession from 1970 to 1975. The trial judge found that Mitchell Gibbons was in fact in a house during that period. It is difficult, Your Honor, to appreciate how Gibbons could have been in the house without being on the land upon which the house stood. It is accepted on all sides that Gibbons was there up to his death, Mitchell Gibbons, up to his death in 1975. The trial judge never considered adverse possession between the period 1970 to 1975, or between 1962 or 63 to 1975. He considered the period from the mid to late 80s to the time of the filing of the action, which was 1996. She found that there was cane cultivation on the land commencing in 1971. But as I read it, the Court of Appeal effectively reversed that finding, that the Co-op Society started farming in 1971, because farming could not take place if Gibbons was residing there from 70 to 75. That seems to be contradictory. If, Your Honors, time only began to run in 1970, as the Court of Appeal felt, then this appeal can only succeed, our appeal can only succeed if that finding of abandonment, that key finding of abandonment from 1975 to the late 80s is reversed. We submit in the first place that the finding is reviewable. I suppose that is the first threshold. two experienced primary fact finders.
Mr. Satram,
Yes,
just to make sure that we isolate the issue that you're arguing, because you seem to be arguing two separate grounds here. One is a ground which arrives at 1975 with the title extinguished.
yes,
And another seems to be a ground which starts adverse possession in 1970.
yes, we do.
So could we just isolate which of those two things you're trying to argue? Because isn't the declaration of title, the application for declaration of title 1970 quite conclusive that we really have to start in 1970?
Well, it depends, Your Honor, on what would be the legal effect of the filing and withdrawal of that petition in 1970. The question to my mind is, does it interrupt his possession? Does it change the nature and quality of his possession? Does it interrupt time? If the general rule is that if an action for possession is filed, for example, by the paper title holder, and it is not taken to judgment, then it has no effect on the possession or on the running of time. So we have a situation here where the petitioner asserted he was in possession. No one disputed that he was in possession, but he then withdrew his petition, supposedly because he didn't make the time. And nothing is done by the owners, by the paper title owners, to challenge his possession or to dispossess him. And the question is, does time continue to run? In our submission, it does.
Would it be reasonable to assume that the withdrawal of the petition is a concession to the fact that the petitioner felt that he had not satisfied the requirements for adverse possession? Coupled with the fact that I gather the petitioner paid the costs of the respondent.
That could be so, Your Honor. In this case, it appears that he hadn't made the time. But
Right.
there's nothing preventing a petitioner upon filing a petition from withdrawing his petition if he thinks he's not likely to succeed. But that doesn't mean that the owner is relieved of that obligation, if it's a statutory obligation, if you want to call it that, to bring proceedings against him or to dispossess him. Suppose
Mr. Satram, the problem is, of course, that all these facts are kind of hidden in the mist of time, if I may put it that way.
Yes.
It is rather speculative. It might have been so, it might have been that. So it's very difficult to take those positions as true. Could you see that?
I appreciate that, but that is why we are relying. He did assert that he was there since 1928, but we are relying on the evidence introduced by the title holders by way of the affidavit in opposition.
Mr. Satram, can I ask,
Yes.
was just for clarification, I may have missed it, was that affidavit before the trial judge?
Oh, yes, Your Honor, yes.
Okay, all right.
It was.
And as you take us there, could you also tell us how the trial judge looked at this aspect of the evidence? Thank you.
Yes. To use the language of the trial judge, the learned judge said that the petitioner was rebuffed. His petition was rebuffed, but she didn't go further to examine the legal implications of the filing and withdrawal of that petition on possession. I may refer Your Honor to page 186 of the record. That's the judgment of the trial judge. At paragraphs at line 15 thereabout. She says that at 1970, the Gibbons' claim to undisturbed possession of the land in issue had been rebuffed.
And then it says Alfred Charles applied to the High Court for and obtained title for lots 5 and 6. The property was vested in his name, along with Malcolm Charles and the plaintiff as co-owners in October 1970. Now, that kind of that procedure was, were your clients part of that procedure, or?
No, please, Your Honor, because if you look at page just a second. At page 239 of the record, you will see the order which was made in Chambers on the 10th of January 1967, which is well before this petition was filed. It's a curious form of procedure. It says that it was instituted under the Deed Registry Act for a registration of title. May have been heard and dealt with ex parte. But you'll see towards the end of the order, it reads that all persons having any right or title to the said immovable property be henceforth forever barred therefrom. And it is further ordered that the registrar of deeds do pass the transport in the name of DeWint over to and in favor of Charles. So they had secured the title since 1967 by that order.
Mr. Secretary, could you please help me here? Coming back to the same section, the same passage where the court said, thus, as at 1970, the Gibbons' claim to undisturbed possession of the land in issue had been rebuffed. And then the sentence following, which we mentioned, Alfred Charles applied to the High Court for and obtained title for lots 5 and 6, and the property was vested in his name, along with Malcolm Charles and the plaintiff as co-owners in October 1970. Did that have any legal effect on anybody's claim?
But I don't think so, Your Honor. Following the decision of this court in Daniel Ramadan and Narayan Singh, the passing of a transport does not affect possession of an adverse possession.
Sorry, this is an application to the High Court, and the High Court made an order. The sentence I read.
Yes, sir.
Yeah. So the High Court order has no legal effect on anybody's claim that they are in possession or that they are in adverse possession. This has no impact?
If that order was made ex parte, as it seemed to have been made, and in the absence of persons who were in possession, in our submission, it does not affect their possession.
Okay.
They were there. The judge made an order not knowing whether they were there or not being told whether they were there. It's difficult to see how that order binds them.
Sorry, Mr. Shepram, just indulge me, just two other propositions flowing from this. An order made ex parte is nonetheless an order in rem, is that correct?
Yes, please.
It attaches to the land, and therefore, help me further, if nobody applies to set it aside, then it is nonetheless, somebody who has not applied to set it aside is nonetheless able to say that, don't dig nothing with that, no?
But I understand, Your Honor, but no one is challenging the validity of that order or the title.
Well, this is exactly what I need your help with, because if no one is challenging the validity of the order or the title, then surely there is some legal implication which flows from the fact that there is a court order which says that you are the title holder and you are entitled by virtue of this to be in possession. Does that not disturb as a legal basis the possession of anybody else?
It vests ownership. That order vested ownership in Charles. It entitled him to possession. There's no doubt about that.
Okay.
There's no doubt that it vested legal ownership in him.
Right.
There's no doubt that it entitled him to possession. The question is what effect it had on the possession of persons who were in there.
Okay.
Charles could have immediately brought an action for possession, relying on that order and the transport which was obtained pursuant to it, and threw Gibbons out. He's perfectly entitled to do that, but he didn't do so, not until 1996, and this case.
I want you to know I have your answer very clearly in my head. Thanks.
Thanks, Your Honor.
Mr. Santram,
Yes.
What was the basis then for that order which gave title to lots 5 and 6 to the Charleses? What was the factual and legal basis for that? Wasn't that they were in possession?
It doesn't seem so because.
But what other ground could there be?
In the opposition that was filed by Charles, I'll direct Your Honor, I'd like to direct Your Honor specifically to paragraphs 5, 6, and 7 of the opposition at page 253 of the record. It is saying there that Johnston Charles, at paragraph 6, was a lawful son of Abraham Charles and Clarity Charles. Abraham Charles acquired the property, but he died intestate on 30th March 1894, predeceased by his wife. The said Johnston Charles died on the 1st May 1937, and his half-sister, Henrietta de Flormont, continued to look after the property and collect lease from the said Joshua Gibbons until her death. So it seemed as if the family had some claim by way of inheritance, I believe. based on paragraph 6, to the property. That's Johnston Charles, who's a relative of the current paper title holder, Alfred, Edward, etc. It seems as if that was the basis upon which they obtained that order and the subsequent transport.
Highly speculative to me, Counsel.
Yes, but it takes us back to the question which Your Honors have been raising is what effect would that have, the order and the ensuing transport on the possession of Gibbon? And as I said to Justice Barrow, nobody's challenging the validity of this order, the validity of that transport. Too late to do something like that in any event. And it did confer rights on Charles, which it did not exercise until 1996.
I'm sorry, just to be clear, you're saying for sure that this was an ex parte order, or are you speculating again as to whether it was ex parte?
Well, the way it is intituled, there's no respondent name. It seems to have been an order nisi, which is usually, it begins by saying so, which is usually an ex parte proceeding.
Okay, well, I think I've detained you long enough in relation to the pre-1970. I'm sorry for doing so. I don't know if you want to move on to the next ground.
That is perhaps our strongest argument. So I
take no responsibility for the strength of your various arguments.
I understand. So, in the event that Your Honors are not satisfied that time continued to run after that order and that transport and the withdrawal of that petition, then our case will depend on time running from 1970. But in order for us to succeed on that point, we have to convince Your Honors that finding, that a key finding made by the trial judge, that there was abandonment between 1975 to the late 1980s, should be reversed. Now, that finding, as I was saying, Your Honor, two experienced primary fact finders made opposite findings, supposedly on the basis of credibility, dealing with the same issue of possession. And that must be of interest to any reviewing court. What was so revealing in the second trial to lead to such a radically different outcome? It must, in our submission, have been something exceptional. The evidence must have been new and thought to have been cogent.
Mr. Satram, excuse me, are you taking us to the evidence in the first trial? Is that what you're doing? I thought I'm not quite following you.
No. There are concurrent findings of fact on an issue, on the issue of abandonment. I'm saying to Your Honor respectfully that in the circumstances of this case, it should be reviewed, or it is reviewable, as it's not ordinary for Your Honor to review concurrent findings of fact. I'm well aware of the rules. And
I followed you up to there. Yes, thank you.
It is reviewable because of the fact that two trial judges have, dealing with the same issues of fact, have come to the opposite conclusions on the evidence. So I'm saying, Your Honor, that there must be something.
Mr. Adam, were those conclusions based on exactly the same evidence?
Well, that is what we must explore.
Okay.
But sorry, Mr. Sefram, in the same regard that my brother is, you are saying you are relying upon the finding of Chief Justice Bernard?
No, please, Your Honor.
The two, what were the two trial judges? Two trial judges made opposing findings. Which two trial judges?
Justice Bernard, Chief Justice Bernard, as she then was.
Right.
And Justice George, yeah.
So then why did you say you're not relying on that? And then, Mr. Satram, and I confess I have marveled at the proposition, and I have been waiting for you to elevate my appreciation of matters. Justice Bernard's decision was reversed on appeal. There was an appeal against her decision, and the appeal was allowed.
The orders, yes, the orders made by Justice Bernard were set aside. Yes. And a retrial.
There was an appeal. Watch me. There was an appeal against her decision, and that appeal was allowed.
Yes.
Therefore, Mr. Satram, can we have any regard in terms of weight of evidence, legal effect, any regard whatsoever, apart from the historical awareness of Chief Justice Bernard's finding?
No, the second trial judge, or Justice George, I should say, was not bound by any findings.
No, I'm not asking if she was bound, you know. I'm asking about what you are trying to do. What you are trying to do with us now is you are saying that two experienced trial judges reach opposing findings of fact. And I am curious as to how we can have any regard to the finding made by Chief Justice Bernard, as illustrious as she then was and certainly still is. How can we, given the legal effect of reversing her, of allowing an appeal against her decision, how can we have any regard for what she may have found?
John, I don't know if I've not been clear, but I'm not saying at all that this court or any other court was bound by the findings made by Justice Bernard. But the evidence, Your Honor will remember that what was ordered was a retrial.
Right.
So the evidence which was led in the first hearing could not have been discounted or tossed aside. It doesn't admission.
Mr. Satram, please help me. This is what I've been yearning for. Help me. How do you arrive at that? What case? What authority is there for this?
Your Honor, I don't have an authority at hand, but
I noticed that.
But if a retrial is ordered on the basis of the same pleading, after the Court of Appeal says that the orders made by the trial judge are hereby set aside,
right.
Testimony that was given on oath in the same case, could it be discounted? Could it be ignored completely? For example, if there was an admission in evidence on oath, could it be, is that somehow invalidated?
With the greatest respect, Mr. Satram, please help me here. Don't ask me, could it be invalidated? You need to tell me on what basis something which is not evidence in a current trial, on what basis something in former proceedings can be brought in as having any evidential impact in a current trial. Give me the authority.
Well, as I said, Your Honor, I don't have the authority, but that is our submission.
Thank you.
No.
I imagine, absent the any relevant directions from the Court of Appeal on retrial.
Yes.
There were no, I assume, from having looked at the documents, there was no such direction from the Court of Appeal that would assist you in this argument, was there?
No, none, Your Honor. We tried belatedly to get the reasons of the Court of Appeal, but it appears that there were just oral reasons. And there was a blanket order.
Yes, I think we're all very, well, certainly I am curious as to why there was a retrial ordered, but we have no indication as to why.
There's nothing on the file, but based on what the instructions my client has given me is that the Court of Appeal felt that Justice Barnard went too far in basically saying that they were entitled to a declaration of title for that piece of land. But I think counsel for the respondent was in the Court of Appeal when that order was read, that decision was read.
And Mr. Satram, one of the things which I found as a former practitioner so very engaging, and I would describe it as adroit, is that counsel for the respondent has very professionally maintained a perfect silence in regard to what took place.
Your Honor will hear from him shortly. But Your Honor, on that key finding, this is the second and last aspect of the appeal. The evidence which the trial judge relied on to support her conclusion on the abandonment issue is at page 142 to 143 of the record. Yeah. Your Honor, to see that the witness was asked specifically whether her father was living there in 1993, to which she answered, no, he used to visit, and that he was visiting from Soestdijk. The witness was again specifically asked whether he was there in 1992. But he used to visit in 1992, to which she said yes. And then finally, whether he was visiting during the period from the late 1980s, to which she answered yes, he used to come and go until his death. And then the final question in that line of our question is, did your father live with you and your family at Soestdijk while going and coming to the land of relief, to which she answered yes. So it was on the basis of this evidence that the trial judge found that the father only started to visit in the late 1980s. In the vernacular, Your Honor, going and coming or coming and going, as I understand it, does not mean that he abandoned the land. I think the witness was saying that he was admitting that he was not living there during this time, but she did not exclude the possibility of him living there earlier, in 1975. because she did say in chief that after Mitchell Gibbons died, that's at page 139, her father lived in the building and was farming the land. So in our submission, respectful submission, Your Honor may agree or not, that evidence was not an admission that he never lived there, as the trial judge found, before the 1980s, or that he did not farm the land in the earlier period, especially after the death of Mitchell Gibbons. The conclusion of the judge on this point is at page 189 and paragraph 20 to 30. So the judge construed that evidence to mean that he first went there in the 1980s. Now, the evidence, the judge seemed, Your Honor, to think that the evidence was contradictory. But in our submission, it was not. It was possible, or it is not a material conflict on the evidence, whether he was living there or he was visiting and farming, because both activities were capable of constituting possession. If he lived there, that was sufficient possession. If he farmed there, that was sufficient possession.
But wouldn't he also have had to possess to the exclusion of the paper owner?
Well, yes, that is true.
Would you not concede that there were acts by the paper owner which would indicate that the paper owner had in fact made, I think, what was called a substantive re-entry by, for example, commissioning the survey in 1977?
Well, the trial judge found that there were at least 2 acts that interrupted possession, and that would be, as Your Honor mentioned, the survey which was commissioned in 1977, and the cane farming which commenced in 1971. We've already dealt with the cane farming issue. In our submission, the survey, which was apparently commissioned for the purpose of demarcating the roadway, did not interrupt possession, because there's no evidence that it went beyond that our clients were dispossessed and they re-entered into possession. That was only, at best, a form of temporary intrusion.
What about the execution of the lease in 1987?
Well, I didn't think that the trial judge was satisfied that Gill actually took and went into possession pursuant to that lease. He said there was no evidence of that. So she did not find that he went into possession and therefore interrupted the possession of Gibbons.
Yeah, thanks.
There is the witness, Addo, at page 119 of the record, that's under cross-examination. Admitted that. Yes, we just.
Sorry, Counsel. You admitted up front that this court is not going to interfere unless there's some egregious error on the part of the trial judge. I hope that you come to this error very soon, because so far it seems to me that what you're calling on us to do is to nitpick. I don't see this egregious error which is going to predispose this court to going there with you. So perhaps you could come quickly to that error.
Yeah, I appreciate that, Your Honor. I'll come to it. And maybe this is one of those points. So at page 119 of the record, you will see that the witness, Addo, admitted that Rudolph Loncke, that's the father of Alexis Loncke, who had died at the time the trial came up, had occupied the property after Mitchell Gibbons died in 1975. Even though this witness had said that there was no house on the land, she later admitted on the cross-examination that there was a shack on the land. So, and there was earlier testimony, of course, by Rudolph Loncke when he was alive, and before Justice Bernard, that he had planted trees on the land. So there is evidence in our submission that Rudolph Loncke.
Mr. Satram, I hate to interrupt you, but you see what you're doing? There was evidence before Justice Bernard. That's what you just said. And you're asking us to have regard to that as evidence in this case, or as evidence that the trial judge in this case ought to have regarded. I really have, I
get your honest point on that. But I still maintain that the testimony given an oath by a witness in earlier proceedings, especially if that witness is testifying again, can be considered against them. But there is evidence in this trial, where the witness Addo admitted that Loncke continued to occupy the property after 1975. Your Honor, on the one other point on this, on the finding, is that there was, the trial judge didn't consider at all that there was a period of adverse possession between 1970 and 1975. And she, in her inquiries, she searched for the appropriate commencement time for the adverse possession. We submit that that may have led her into error because she was dealing essentially with the period of abandonment was essentially caught between two periods of adverse possession, where adverse possession was clear. That's from 1970 to 1975. And then from, as the trial judge found, from late 1980s to the time of the filing of the action. The final point, I don't know how strong this point is, but there was no prayer for an order for possession in this case. Your Honor, you see that there was a declaration was sought. That
Mr. Safram, perhaps I may help you in this regard, or we can help each other. You say you don't know how strong this point is, but wasn't there an injunction?
An injunction was sought and granted, yes.
Mr. Safram, as a practitioner, is not an injunction stronger than an order for possession? An order for possession entitles the recipient of that order to execute, to get an order for ejectment. The order for possession does not command the person who is in possession to get out. You get an order for possession and then you seek a writ or whatever to get the person out. An injunction is an order to a person who is doing the wrong, who is wrongfully in possession, to get out. Yeah?
The two injunctions were sought in this case. One, the first one at that paragraph of the release on page 61 is to prevent the completion, the building or completion of any structure now in progress. Because there was an issue at the commencement of the trial, that at commencement of the case, that works were ongoing. And then the second injunction is one directed to the defendant to dismantle and remove any and all structure which they have built or caused to be built on the land. The plaintiff's case was that these structures were only built just before the commencement of the action. And of course, there are other items of property on the property, such as pens and so on. The order which the trial judge eventually made is in similar terms. So, but based on the authority that we have found, Gledhill and Hunter, the declaration may not be sufficient. We have found nothing which deals specifically with injunction. But Your Honor has helpfully pointed out that the injunction may even be stronger than the possession order. But it does not appear that the injunction was complete. It did not deal with all the structures on the land. Your Honor, that will be the extent of our submission, unless Your Honor has anything else.
Yes, Counsel Mayor?
Yes, Richard.
Yeah, there's one little matter which concerns me a little. I think you made reference in your written submissions to the court to the British Columbia case of Moet.
Yes, sir.
Do you have anything to say to this court in respect of that?
Yes, sir. First of all, Your Honor, I must apologize that we didn't, we weren't aware, at least we didn't come across the Supreme Court decision in our research. We don't practice in that jurisdiction. We're not, research didn't point us to the fact that it was dealt with by the higher court.
But there's a section in Canley which talks about treatment of a case, and if one clicks on treatment, one would have seen that the decision was reversed the year after, 2017.
Yes, Your Honor.
It's just that this court is the apex court, and even though we're not bound by British Columbia precedents or the Supreme Court of Canada precedents, I mean, it's open to you to tell us choose, and we have a right to choose. But I just feel that we have to recognize that we have to help this court as much as possible. I just thought I'd make that observation.
Your Honor, please accept, and I apologize to the court as a whole, please accept our sincerest apologies for that. It was in no way deliberate. That we did come across it, I believe, in a text, and I wasn't careful enough in the research to confirm.
So I should say to you that there was quite a lot of talk about in Canada, not only in legal journals but certainly in newspapers and so on. One which said, "Don't mess with trial courts." So I just find it a bit. We weren't. This wasn't drawn to our attention, the Supreme Court decision. But this is not to belabor the point. This is just to say that we attempt to be excellent in our judgments, and to the extent you can help, I would suggest that counsel should help. But this is not to belabor the point or anything of the sort. Thank you.
I appreciate that, Your Honor. And again, Your Honor, it was not our intention to mislead the court. We were genuinely not aware of it. If there was an error on our part, please forgive us.
Okay, Mr. Santram. I don't think we have any further questions. We'll take a short break, so stay on. We will be back soon enough. I suppose 5 or 10 minutes. I'm not sure about that. And then we will be back. So stay on. We will withdraw for a moment.
Thank you.
Madam Deputy Registrar, we will resume as soon as the bench is complete. I think.
Justice Burgess, yes, I'm seeing
Yes.
Justice Burgess, yes, and I'm seeing.
So
Are you seeing Mr. Ford? I'm not seeing him from my end, Judge. Is he there?
I don't see him yet.
Yes, he
There
is.
he is.
Court resumes. Thank you, Judge.
Okay, thank you very much. Mr. Satram, we appreciate the valiant attempt that you have undertaken to persuade us, but we are not. And so we think it's not necessary to hear Mr. Ford at this point. That only will lengthen the proceedings. If we are not convinced at this point, then it is now no use. Lengthen the procedure by listening to Mr. Ford, although we would like to hear him, of course. Nothing against that, but it would not be necessary as we see it. And so we are right away in a position to give you a decision. Decision is that we dismiss the appeal. We affirm the orders of the Court of Appeal for basically the reasons that the Court of Appeal has given. And as we understand that you agreed costs at this instance of 750,000 Guyanese dollars. So
Yes,
we will order costs for the respondents for that amount of money as agreed between the parties. That is the decision of the court. So it is a little shorter than you may have expected, but as I said, and I think that was quite clear from the remarks of the bench, that we really needed something more to really get down to a more critical assessment of the judgment of the first of the trial judge. It was a thorough decision. It was affirmed by the Court of Appeal, and we don't think there is any possibility of doing anything about that. So we keep it short. That is the order of the court for today. Mr. Ford, unfortunately, we are not hearing you, but anyway, I think you are pleased. You will be pleased with the result. So that's.
So, Your Honors, thank you very much. This is one of the occasions when I'll be quite happy to be silent.
Great. Okay, thank you very much.
Your Honor, again, I'd like to apologize to the bench for the point that Justice Burgess was raising earlier.
Yes, well, I'm not going to belabor that again. Yes. He made the point. I don't think any of us has any of us think that you did that on purpose or something. It is just a little hint that when you prepare a case and you bring forth a case, better prepare very well so that you won't miss anything that you did miss in this case. But we have no hard feelings, so to speak. We understand it was not on purpose that you did that. This is what we assume. Having very good experiences with you normally. So that is it, what we can say about it. We hope it's a little lesson, and not just for you, but anyone who comes before this court, so that we get well-prepared submissions. That is all I think I should say about it. Don't feel too bad about it. So thank you very much. Madam Deputy Registrar, could you please close the proceedings?
Yes, Justice Witt. Thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnatli. Thank you, Mr. Justice Barrow. And thank you, Mr. Justice Burgess. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.